Uniform Trust Code cases from 2020. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Susan Snyder, ACTEC Fellow from Chicago. We had a couple of new cases applying the Uniform Trust Code, or UTC, in 2020. To give us more information on those cases, you'll be hearing today from ACTEC Fellow Rebecca Wallenfels of Chicago. Welcome, Rebecca.
Thanks, Susan. I'm happy to be here today. And I just want to highlight three cases that came out that caught my eye, and I hope all of you will find interesting as well. The first is from Kansas, the Kansas Supreme Court. It's in matter of Jill Petrie St. Clair Trust. And that involves a reformation of a trust that, and the reformation was designed to avoid the reciprocal trust doctrine. So that one caught my eye because in the year of 2020, I see so many planners doing slats, for example, for couples, and this involved a slat, and probably a slat that had gone wrong, and I think they were trying to fix it. So this case, the husband and wife created identical trusts for each other, right? And literally identical trusts. The only difference between the two trusts were the names on them, who the donor was, and the spouse identified as the beneficiary. Otherwise, same exact terms, same dollar amount gifting. They were just done maybe a year apart. So what the wife did in this case is, with the drafting attorney, they petitioned the court to reform the one trust for the trust she created for her husband, to add in the provisions that they alleged were inadvertently omitted due to a Scrivener's error. And so they did this under 415, the Uniform Trust Code. So that's the provision that allows for reformation if it's proved by clear and convincing evidence that there was, in fact, a mistake made. So they did this not only at the trial court level, but they were able to, under the Kansas local rules, appeal this ultimately up to the Kansas Supreme Court and get a Kansas Supreme Court decision issued reforming the trust to try to avoid that reciprocal trust doctrine. So they were successful in getting the Kansas Supreme Court to give them an affirmative opinion, which will be useful to them. Now, what's going to be interesting to see, and if we actually get anything out of the IRS on this, if it ever goes through a tax court case, to see how the IRS views this, but certainly from a property law perspective and a trust law perspective, they took the steps that were needed, and proceeding under 415 was the perfect way to go, to set them up for that tax argument, because what 415 does with the reformation is it arguably, right, made this retroactive to the original trust, so that these trusts always had different terms. That was at least the Supreme Court's decision. So that case is out there. It's worth reading. And if you find yourself in the situation as a draft person or someone that's trying to defend trust, here's something to look at as maybe a model. So that's one case. The other one is one that's also interesting, I think, from a draft person's perspective as well as from a litigator's perspective, and that's Garland v. Miller. And that's a Kentucky appellate court case. And this one is interesting because here, settlor and beneficiaries were looking to modify a trust, an irrevocable, non-charitable trust, under the UTC Code Section 411. So it's the Kentucky version of 411. And what's interesting about this one, the reason why this caught my eye, and was an interesting read, is the basis for the court's ultimate decision, in this case, to allow them to terminate the trust. So just a little bit of background on the UTC for those of you who don't know your UTC code sections cold. So 411 allows a settlor and the beneficiaries, by consent, to modify an irrevocable, non-charitable trust, even if the modification or termination is inconsistent with the material purpose of the trust. So basically, that is a very broad standard that allows settlor and beneficiaries, if they can all get together and all agree, to change an irrevocable trust. And that's what they were trying to do in this case. The trustee here is objecting, which is why we end up in an appellate court decision. And the court actually agreed and said, no, you can't do that. And the reason why is because it was an irrevocable trust in which the settlor expressly waived any right or power to ever terminate this trust or modify the trust, right? Which are typical irrevocable trust provisions. So not only do you say the trust is irrevocable, but it specifically waives and releases any power or right to terminate the trust. And because that was there in the trust agreement, the Kentucky court said you can't use that provision of 411 because your trust document says something else. It says you're giving up this right, so it's not applicable. So just be aware of that from both a drafting perspective, but from a litigation perspective, if you're trying to reform it and looking at that code section, pay attention to your provision about what makes your document irrevocable. And, are you going to be in that kind of fact pattern where, because of the rights released by the settlor, that option under 411 is not available to you? Now, luckily in this case, the Kentucky UTC also had different provisions under, 411B that allowed a court to still modify, so long as they thought the modification or termination was necessary to achieve a material purpose. So they still could accomplish what they wanted to. It's just they didn't proceed the way they thought. So, and this might be useful for anyone doing some planning if they're concerned about their UTC statute and the power a settlor has to consent to a modification or termination. Robust language in your trust agreement may avoid that issue of 411. And the last case I just want to highlight is came out of Nebraska, and it is In Re Trust of Margie E. Cook. And this is a case, and there's been a series of cases on this, and this is, I think, just the latest, that address the question of whether future beneficiaries of a revocable trust have standing to contest kind of trustee provisions or trust modifications or terms of a document while the settlor is still living. And there's been a couple of these. This is just the latest one, which is why it caught my eye. And in this case, the Nebraska Appellate Court, our facts were they were friends of the settlor who were named in a document. They were contesting both the validity of a trust amendment as well as a sale by the trustee of a condominium that had otherwise been left to them. And the Nebraska court said they lacked standing. They couldn't challenge validity of the trust or an amendment to the trust. They had no standing to contest, the trustee's actions based on the provision of the UTC, it's section 604, that says really the settlor is the only party in interest. And here, although they argued that the settlor was incapacitated, the court said it didn't really matter. Didn't matter. That was there. That wasn't relevant to their conclusion. They said you, by virtue of being a future beneficiary of this document, you've got no standing. It's just the settlor and the settlor's authorized representative, if in fact the settlor were incapacitated, who has that standing. And that's, contrary to a Michigan appellate court case, In Re Brody Living Trust, that came out in 2017, that reached the opposite conclusion under their version of the Uniform Trust Code that said a daughter had standing to challenge the actions of a trustee. So there you have it. Those are my handful of cases under the UTC that we're taking a closer look at from this year.
Thanks, Rebecca. All very interesting. The second case is a good reminder. We are now used to being allowed to modify irrevocable trust, that we may forget to pay attention to how our trust document describes that irrevocability. So thanks, Rebecca, for highlighting those very useful UTC cases.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review. Follow us on Facebook and Twitter at ACTEC Talk.